So this is a controversial area, let me say, from both a lawyer's point of view and a law professor's view. Before I can go and start to say which forms do I think are the most helpful, I think we actually have to ask a question, which is, do we really need specialized legal forms? And that's where a debate continues to rage within the United States and elsewhere. But you're correct that there has been a lot of states in the United States, because this is the level where this takes place. It's not at the federal level in the United States, where new legal forms are being set up. And so we have been at the Grennan Center tracking through the Social Enterprise Law Tracker how state legislative initiatives are going forward. And what's been interesting is the most popular is the benefit corporation by far. There are 40,
the legal form of benefit corporation.
The legal form. Yes. There is a thing called the B Corporation, which is a brand. And I actually wrote an article that you published on Impact Entrepreneur about how on the bar exam, the examiners confuse those two terms,
yes,
which is really troubling.
On the bar exam confuses it. Yeah. Everybody, yes. A lot of people do, but you don't want the bar exam doing that. Yeah.
Yeah, we're a work in progress.
Yeah, I guess so.
The Benefit Corporation is in 41 states if you include the District of Columbia. It's by far the most popular. Now, just counting, however, the number of states that have laws, you'll start to see one thing, which is very few new pieces of legislation are being passed at the state level in the United States right now. And in partly, it's because the states that have wanted to have already done it. But what's maybe more important, and this is where we lack a lot of reliable data, is are U.S. social enterprises incorporating in these forms? And if so, what ones are they choosing? And that lack of transparency and understanding could lead us to maybe overvalue these legal forms. They may not be being used as much as one might think. And so there are some that have studied social enterprise. And I think the data I'm going to cite goes back to 2023. I'm sure there's something more recent. But as of the end of 2023, there was an estimate that there's 10 million social enterprises globally, and that they comprise 3% of all businesses in the world, and they generate around $2 trillion in revenue. That's big. Now, of that amount, the United States, people think, have about 1.3 million social enterprises. So we are one of the largest ecosystems in the world for social enterprises. But I could not tell you how many of those have incorporated in one of the specialized legal forms. And if so, which ones? And that is a big question for all of us. One of the things that happened in 2024, and I'm going to get a little technical here, there is skepticism about whether you need these new forms or whether the traditional corporate structures provide sufficient room for directors to make decisions that address bigger stakeholder interests than just the shareholders' short-term financial gain. And there are some who have felt that the specialized legal forms are somehow suggesting that the more traditional forms actually require a narrower purpose. And so that's where this debate is going on. In 2024, there was a very interesting Delaware Chancery Court decision. And I look at Delaware quite a bit because that is the jurisdiction where most companies that want to go public end up incorporating at some point. And this was a case of an investor who was suing Zuckerberg and other leaders of Meta. And in this decision, it was dicta, but it was quite interesting. The Delaware court noted that if broader stakeholder interests needed to be taken into consideration in the decision-making at Meta, that Meta could have formed itself as a public benefit corporation in Delaware, but it didn't. Or it could have put in its charter broader stakeholder interests that it was going to pursue, but it didn't. And that is the precise issue that some are getting nervous about, because the court then went on to say, well, we don't see that, so therefore we're not going to impose a broader purpose on Meta. Now, you can glass half full, glass half empty. One could also say, well, isn't that Delaware saying that if you did have this private ordering, having someone put it into their charter, and going in under the traditional corporate form, or choosing one of these specialized, that the court will really hold those decisions that are made on those boards that may in fact prioritize interests beyond just the shareholders' interest, will be held up and will be defended. And that's what I'm watching at this stage. I think there's a very interesting question, and I'm not going to hazard my opinion at this point, but as we see groups like OpenAI choose the public benefit corporation form, watching how they actually then act, and if they act in any way that's different than just prioritizing short-term interest, I think that'll be, how effective are these forms in really shaping what goes on in the boardroom, in shaping the liabilities or litigation risk of companies that choose this. I'll give one last piece on this because I think it's something I've seen, but again, I can't tell you how many are doing. I just can tell you it's starting to become visible to me. I've had clients that have chosen in Delaware not to become a public benefit corporation, but to go the traditional C corporation route and then do what we call private order, put in their charters, their mission. And when I've asked them, why didn't you take advantage of this new legal form? They said, well, they weren't entirely sure what would be asked of them and whether those rules would change. And anybody who's watching the B Lab's work this year will know that there is some additional accountability that the benefit corporations and B Labs themselves, or the B Corps themselves, may start to have to respond to. And as that happens, I think it's admirable to be trying to avoid impact washing, but I think legal uncertainty has a chilling effect. So we may see a chilling effect occur as these new expectations are rolled out upon how much corporations actually want to lean into some of these new legal forms.